The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, Realtors. Thanks for joining South Carolina Association Realtors commercial webinar, Environmental Issues, What Realtors Should Know About Commercial Due Diligence. With us today, we have two very special guest attorneys. Burnet Maybank is currently a member at Nexsen Pruet Law Firm, specializing in economic development, state and local taxation, tax controversy, tax law, and public finance. He is a two-time former director of the South Carolina Department of Revenue under both Governors Mark Sanford and Governor David Beasley. Burnet has also served as the chair of the South Carolina Tax Realignment Commission, aka TRAC Commission, the South Carolina Transportation Infrastructure Study Committee, and on the boards of multiple civic organizations. He's been recognized by the Columbia Metropolitan Magazine as one of the best lawyers in the Midlands for 2015 and best lawyers in America for tax law. He is also a two-time recipient of the Order of Palmetto and has authored countless books and law review articles. We are very honored to have him with us today. Partnering with Burnet is also a member of the Nexsen Pruet Law Firm. We have Tommy Lavender, whose background in environmental law spans 30 years. Tommy started out at South Carolina DHEC as an environmental engineer and was quickly promoted to assistant general counsel. From there, he worked for a capital corporation and then went on to Nexsen Pruet, where he is now chair of the firm's environmental, administrative, and regulatory law group. He has been named as a fellow at the American College of Environmental Lawyers, South Carolina Super Lawyer in Environmental Law, 2008, 9, 10, 12, 13, 14, and 15, and one of the best environmental lawyers in America since 1995, and was listed in Chambers and Partners USA as a leading individual in environmental law, among his many other accomplishments. Thank you both for being here with us today. We'll hand it over to you. Thank you.
I guess I'll start. Got these slides. Good afternoon, everybody. This is Tommy. I'm going to start with what I hope we will be able to cover today in an hour, maybe less. But these are the topics to which I will direct your attention, trying to identify the issues that you're likely to encounter. Many of you may have heard this commentary previously. And I'm a fan of not reading you the slides and talking more on the subject. But we'll go through each of these three bullets in an attempt to cover these topics and hopefully answer any questions you might have. I'm not sure whether we'll do them during the presentation or at the end. I think it's as they come in. First of all, with respect to due diligence, and we're dealing principally, if not almost exclusively, in the commercial real estate arena. This applicability for due diligence and liability protection really has little applicability to residential transactions unless those are previously used residential structures where there's going to be a proposed commercial use. Clearly, these are the types of due diligence topics that a commercial transaction should include, both the Phase I, obviously title examination, possible surveys depending on the nature of the transaction. The acronym for BFPP it stands for Bona Fide Prospective Purchaser. Building inspection, obviously, depending on whether or not the building or there is a building or whether we're dealing with a greenfield site. And voluntary cleanup contract. Due diligence from an environmental standpoint necessarily should start with a Phase I environmental assessment. I'll get into a little detail about the content of Phase Is and the complexities of Phase Is, as well as the importance of understanding the contents of a Phase I ESA report. I'm going to talk about wetlands and the impact that wetlands can have, and the exposure from a liability standpoint that impacting wetlands without proper authorization can expose a developer, contractor, consultant, anybody that has anything to do with that unauthorized impact. I'll touch a little bit on stormwater and land disturbance activities, and only briefly on asbestos and lead in existing structures. Real estate purchase agreements, each of these other topics we'll get into more detail on them in terms of content of purchase agreements, both from the purchaser side and considerations from the seller side. We see different issues with different positions on either side of the table, so it's important for at least from our perspective, to understand those distinctions. And Bernie's going to also address issues relating to brownfield incentives available to redevelopment of brownfield sites. Those are previously owned sites or previously used sites that may have been impacted by former industrial activities or commercial activities. Liability. Liability is expressed generally in our terms as potential responsibility, potentially responsible party, or PRP, for environmental conditions that exist at the time of the purchase. Obviously, it's important from a purchaser's perspective not to take on or assume the liability for the existing conditions of the property. We're part of the environmental due diligence and commissioning of Phase I is to attempt to identify what those conditions might be, or what previous uses of the property might have created environmental conditions. In liability terminology and statutory terminology, that imposes an obligation on a commercial purchaser to make all appropriate inquiries. And that's a term of art, again, in the federal Superfund statute, which has been adopted by reference by the South Carolina General Assembly. You may hear me refer to it as AAI. However, there are other defenses. If a PRP, potentially responsible party, had no reason to know that there were any conditions, meaning you did your Phase I and you still didn't know, you have a defense. That's an affirmative defense. It doesn't mean you're not liable. It means you've got to prove that you had no reason to know. You inherited it, for example. We're dealing with one of those issues right now. We've asserted that affirmative defense to DHEC in a transaction in Columbia at the present, where our client inherited a piece of property that was previously used as a manufactured gas facility here in Columbia. Or it's a public body which took the property at a tax sale, or condemnation or other involuntary transfer. No reason to know. That's important. No reason to know. The only blue pencil test in order to assert that the purchaser had no reason to know is a Phase I environmental assessment that meets the requirements of the AAI regulation, which is a federal regulation administered by EPA and encompassed in South Carolina's Brownfield program. So all appropriate inquiry is embodied in and established through the performance of a Phase I assessment. And that came into vogue after 2002, when the federal Superfund statute, or CERCLA, was amended to include the affirmative defense for a bona fide prospective purchaser. Understanding, however, that absent that defense, an owner of a property is strictly, jointly, and severally liable, meaning you're just as liable as the prior owners for any condition of the property, unless you have that affirmative defense and can assert that affirmative defense. Again, and I'll repeat, Phase I environmental site assessment. That I've spoken about the statute being amended and the BFPP, and the defense is actually much more favorable than the previous common law defense as an innocent purchaser. The BFPP language in the revised federal statute has much more precise criteria for establishing that affirmative defense, particularly after EPA adopted the AAI regulation, which set out the requirements for that defense and then which were embodied in the ASTM standard for Phase I site assessments. The defense contains a number of elements. First of all, you can't have been responsible for it. Typically, in an arm's length transaction, the buyer's not responsible, but the buyer can't be affiliated with the seller. That's the last bullet. But as long as it's an arm's length transaction and the buyer's not had any previous involvement with the site, that should satisfy that component of the BFPP defense. All appropriate inquiries, the Phase I. Appropriate care is a post-closing obligation in order to preserve the BFPP defense. You must, if a Phase I site assessment identifies what are referred to as recognized environmental conditions, but the buyer decides to proceed, it must exercise appropriate care with respect to those conditions to avoid any release that would exacerbate that condition. For example, if the site has contaminated soil but it's under a slab and the buyer chooses to move forward, they're fine as long as they don't tear up the slab. But once they tear up the slab, they could, and there's a South Carolina case on the subject, that they could assume liability for that condition and any resulting spread of that condition if it's contaminated soil and it migrates into the groundwater. That would expose the buyer and dilute its affirmative BFPP defense. Cooperate with the government. Obviously, if it's an existing ongoing environmental condition and the government's like a UST site, the government needs access, or the government's contractors or responsible parties need access. Same with land use restrictions. If there are land use restrictions, industrial controls, like not digging without notifying DHEC or not using the groundwater for drinking water purposes, again, those are the types of things that are required post-closing to preserve the defense. AAI, as I said, the All Appropriate Inquiry Regulation went into effect in November of 2006. That's not to say that Phase I environmental site assessments weren't usual and customary prior to that time. They certainly were usual and customary. I think one of the earliest Phase I standards might have been '89. They're generally on a 5-year cycle. ASTM reviews and reissues the standards. But there was one again in '97. The standard that incorporated all of the AAI requirements for establishing and preserving the BFPP defense was in 2008, and that would have been E152708. You should see, as you solicit Phase I's for purchasers, you should insist upon and see E1527 as the standard to which the Phase I is intended to comply. The current standard, I think, is 1314. I don't have it in front of me, but it's more recent than 08. So there are no other standards. The all appropriate inquiry rule, the federal regulation contained in 40 CFR Part 312, has one section that lists the methods by which one can achieve compliance with the 10-15 page regulation, and it lists E1527. It lists no other means. Everything else is blank. So right now, the only way you are assured, unless you go through and check every box in the regulation, or your consultant or the buyer, is to do an ASTM Phase I report. There are a number of different standards, and they vary with respect to these particular requirements. But in any event, 224708 is the forestry standard. You can do that for forestry property, undeveloped property, completely undeveloped timber property, forestry agricultural. That's a simplified approach. It should be somewhat less expensive than the 1527. Since recently EPA eliminated 152708, so you should not receive any Phase I that refers to E152708. We still have seen some in the last year. Phase I does not tell you if the site is contaminated. The Phase I does not include any testing. The Phase I only includes essentially the elements shown here, and I think on a subsequent slide. A site visit by the consultant, reviewing state and federal records and databases, and along with other data such as the aerials, directories, and Sanborn maps. Assuming most, if not all of you, should be familiar with, particularly with historical aerial photographs. Google Earth is a good source for just a back of the envelope type look at particular properties. City directories at the library, as well as Sanborn maps. It also, Phase I also includes history of the ownership. Generally, and as a component of a Phase I, that history of ownership should include a chain of title, not the title exam or title policy or title binder, but at least a chain of title to identify to the consultant the prior owners of the property, because the consultant in a Phase I is expected to look at the historical uses of the property back to the time that it was developed for the first time. That could be longer than the period generally relied upon for marketability of title in a title examination. So it could be 100 years. But in any event, they also include interviews with persons familiar with the past use of the property. Again, the Phase I is non-intrusive. There is a shelf life for a Phase I. It's very important in asserting the BFPP defense. I generally refer to it, like many of us are familiar with the term, a born-on date. It does not correspond to the date on the cover of a Phase I. The consultant typically puts a date on the cover of the Phase I when they, quote, publish the Phase I. But the Phase I has a born-on date for purposes of its validity at the time of closing for asserting the BFPP defense at that point and in the future. And that born-on date commences with the date of the earlier of the date of the site visit, or the earliest day if it's a 2-day visit, the earliest of the owner-operator interviews, or the database search or lien search. So understand that those 4 bullets under the 180 days have a shelf life of only 180 days from the time those activities occurred, when they were undertaken. Beyond that, the balance of the Phase I has a total shelf life of 365 days. For example, and we just went through this week on a Phase I in downtown Spartanburg. The Phase I was performed in November of 2014. The closing is not expected to occur until 4th quarter of 2015. So it was possible for the Phase I, or it was required for the Phase I to be updated with respect to these 4 components: site visit, interviews, database, and lien search, because they had expired from November plus 180 days. I don't know what the date was in November. So they updated those 4 components and issued an updated report. Again, the validity of that report was still only valid for November of 14 plus 365, whenever the balance of the Phase I was undertaken. So again, there are some complexities associated with this. We're fairly keenly aware when we advise the real estate or dirt lawyers of the due diligence activities, and in particular tracking the Phase I and its validity at the time of closing. And closing gets pushed. We've seen the need to update or reissue. I mean, not reissue. Secure a new Phase I. If closing were not to occur in the transaction I just described until December, in early November, we would be advising the client to get a new Phase I, not refer to, update, or reissue, but get a new Phase I, all of the components of it having to be undertaken again. That's important if there's a chance or reason to believe that liability defense is going to be there. And it protects against unknowns because you've made all appropriate inquiries. This is important. We see this a lot as realtors or brokers, commercial brokers and agents are involved on the front end in securing a Phase I for a buyer, prospective purchaser in our case, and the consultant is contacted by the broker, and the consultant issues the report to the broker. And the broker is identified in the term of art in the ASTM standard, and thus the Phase I is the authorized user and the only entity which is authorized to rely on the Phase I for the BFPP, meaning that when the buyer is ready to close, they don't have a valid Phase I. They're not allowed as a defense to rely upon that Phase I because it limits those to whom are authorized to rely on it to those authorized users. So what you typically, and we'll hear the term used, is a reliance letter, meaning get the environmental consultant to issue a reliance letter. Well, that's all well and good. It is our opinion that that document, whether they want to call it a reliance letter or not, should be issued as an addendum to the Phase I and add the actual entity which will be the grantee in the transaction as, quote, an additional user, end quote, and which would necessitate the buyer, just like the broker was asked to do if they were done properly, to complete the user questionnaire, which is a required component of a Phase I. That is, the buyer, prospective purchaser, would answer a number of questions with respect to what they know about the property and what their intended use of the property is. I think I've referred to the transition between the 08 and the 13 standard, but one of the things that we strongly urge is that they not use the 08 standard, and if they have even made mention of it, to try to get it removed. Other issues that are not ASTM Phase I issues and are specifically identified in the Phase I standard as non-scope items. I might add, if you have any intellectual curiosity about the Phase I standard, you can either look at the regulation or, more importantly, acquire a copy of the standard from ASTM. I'm not peddling it. I'm just telling you it's a copyrighted document. Wetlands, asbestos, and all of those other items are non-scope items. They are not part of a Phase I. They would not be addressed in a Phase I that meets the requirements of the ASTM standard and the all appropriate inquiry regulation. They would be very prudent in many instances to be investigated, and we'll go into a few of those later. Wetlands. Wetlands are important. Pretty pictures are nice. They don't tell you whether they're wetlands or not. You're going to need a wetland scientist. Prospective purchaser should definitely investigate the presence of any jurisdictional wetlands, not just wetlands, but jurisdictional wetlands, or should I say not just jurisdictional, but wetlands. There can be wetlands, but not necessarily jurisdictional. So as a result, it's important to look at the presence of wetlands if there's going to be any development of the property, including a road across what you might think is a ditch or a creek. So be aware of that. We're dealing right now with industrial development to include 6 proposed buildings in the upstate, and it only requires an access road to cross a swale, but which was identified by the wetlands consultant as a perennial stream initially. It required a permit from the Corps of Engineers. Because they called it a perennial stream, the Corps of Engineers nationwide permit had not been certified for perennial streams by DHEC. So we ended up having to go get an individual 401, added a lot of time to the process. So those are important things to consider on the front end of wetlands. If an individual wetlands permit, if your impacts are going to include something greater than 1/10 of an acre generally, or 300 linear feet of impacts, and an individual permit is going to be required, you need to plan on a year to a year and a half or more for an individual permit, as well as the costs for mitigation. The general premise under the federal wetlands program is no net loss of wetlands. So any impacts to wetlands must be accounted for by mitigation credits or some other means of compensatory mitigation. Federal jurisdiction for wetlands vests in EPA through the Clean Water Act. But we deal with the Corps of Engineers. The Charleston Office of the Corps of Engineers is the district through which South Carolina is regulated. The Corps has, in the last several years, established 3 field offices outside of Charleston, Beaufort, Columbia, and Conway. So many of you should be dealing or may have dealt with through consultants these field offices now. It's a lot quicker, although it's still a long time to get jurisdictional determinations. And I'm going to go into a little detail about jurisdictional determinations in a minute as it relates to delineations. But suffice it to say that the Clean Water Act prohibits filling in navigable waters, including adjacent wetlands. It also prohibits excavating from navigable waters. Navigable is different from just jurisdictional waters. Any party, and I mentioned previously, a developer, engineer, or contractor. We had an enforcement matter a number of years ago where the developer went to a civil engineer. The civil engineer looked at the property, decided that the developer should consult with a wetland scientist. The developer did that. The wetland scientist identified what they believed to be the jurisdictional wetlands. The civil engineer laid out the subdivision and avoided all of the jurisdictional wetlands identified by the consultant. The contractor went out there and started work, and the Corps of Engineers, as they typically say they do, drove by. And they observed the activities at the site and had a difference of opinion with the wetlands consultant. As a consequence, they stopped the project, notified each of them that they would be taking an enforcement action. They stopped the project, meaning they issued a cease and desist order. They posted it at the site and told each of them that they were going to commence an enforcement action and look for $100,000 from each of them. Obviously, the resolution of it involved something significantly less than their initial demand, but nonetheless, it stopped the project for quite some time. So any party can be responsible if they participate in the unpermitted activity, even if they did it innocently. Wetlands evaluation starts with the wetland scientist. The wetland scientist does the preliminary assessment and then provides a delineation. That essentially is the wetland scientist's opinion. And this is just like lawyer opinions, Bernie. It's what you pay us. It's worth what you pay us for it, but it might not keep you out of court if we're wrong. And it's more important in this case, it will not keep you out of court if the wetlands consultant's opinion does not agree with the Corps of Engineers' opinion, which means that the last step I've described in there is the most important step. The delineation is only protection if the Corps of Engineers agrees with it, and they do that in the form of a jurisdictional determination. That's a letter on Corps of Engineers letterhead. It takes generally one of 4 forms, either an approximate or an accurate preliminary or an approximate or accurate final jurisdictional determination. So look for those types of documents in developing site suitability for a project that's going to move forward with construction activity as opposed to just buying an existing shopping center and repurposing, for example. But these are the types of things that the wetlands consultant would be doing by necessity in order to evaluate that. Those are things that you might already be able to do by just looking at the county GIS. Many counties have very good GIS systems, and I've looked at most of them that are available from time to time because of various projects we've worked on, and they have these different layers, the topo, the wetlands inventory. Don't be completely spooked by the National Wetlands Inventory. It's not definitive in nature, it's only instructive. It's very broad. It's a very broad layer that you can drop down on it. It'll only tell you that you need to start the process. Same with flood insurance maps. Just because it's in a flood zone doesn't necessarily mean that it's wetland or that wetland is jurisdictional. Same with the soil maps. But soil characteristic is a component, one of the three components of a wetland. And then similarly, aerial photographs. The aerial photographs in conjunction with the USGS topo map, where there are blue lines, for example. If your client looks at a USGS map and wants to put a building down across a blue line, that ought to be a red flag, not just a blue flag. But the wetland scientist is the one to start that process. You certainly want their opinion. You want them to flag the areas. And then if you want an accurate survey, because you're either going to avoid or you're going to get a permit that is, you need the precision of how many acres or linear feet of jurisdictional areas will be impacted, you'll need to have the surveyor come out there and put it on a plat that needs to go with the request for the JD. The surveyor can't simply rely on whatever the GPS coordinates that the wetland scientist shot with his little handheld GPS. The engineering board has issued an opinion that the surveyor would be committing an impropriety if they take that information from somebody who was not under their direct supervision. So be mindful of that. That's a little known opinion issued by the engineering board, one of your fellow licensing agencies. Submit the JD request along with the plat to the Corps. Alternatively, if there are no wetlands there, you can request an upland determination, and that just simply says the Corps agrees that there aren't any wetlands out there. Have at it. Again, preliminary approximate was issued without a plat with no meets and bounds, just a sketch. The final JD, an approximate or accurate, is valid for 5 years. Be aware of that if the project is likely to require the issuance of an individual 404 permit. You don't have a year and a half or so left during the validity of the JD. It is important to have the consultant have the jurisdictional determination reissued. Keep your fingers crossed that it hasn't changed for the worse, I guess, for lack of a better. We have several projects in the lower part of the state where the 20% cover of wetlands, jurisdictional wetlands, has gone up to the 30 to 35% or more in some cases because of the change in the wetlands determination guidelines as a result of a Supreme Court decision in 2008. So pre-Supreme Court Rapanis determination is much more restricted than the post-Rapanis ones, which seem to capture more wetlands which were previously not jurisdictional. I know that's bogging down in detail, but I think you just need to be aware of it. I think y'all are getting these slides, so it might give you some insight about it. And otherwise, I'll do what Bernie will make an unmitigated plug that we've got offices in 5 locations in South Carolina if you have a question. Threatened and endangered species, is only required if a federal permit is required, meaning if you've got to go get a Corps of Engineers permit, then you're required to do a T&E, bugs and bunnies. If you're not, many large and institutional developers will do that anyway as a matter of just practice. But it's not a requirement at the state level for any of the state permits. So be aware that sometimes you don't know to ask the question, why are we doing it? It's an appropriate question, because let me tell you, when you do it and you find an threatened or endangered species, you may as well add more time to the process. We've actually been involved in relocating habitats, particularly on the plant side. We've been successful, but it took time to relocate an endangered sunflower that only seems to occur in the York County area of South Carolina. It actually was named for a Winthrop professor who discovered the species. So be aware that that's not a routine and is not a requirement if you're not going to require a federal permit or in some respects get federal funds, which requires an environmental assessment. So if it identifies species or habitat, add some more time to your timeline. I might add that a lot of consultants like to include what are referred to as the state species of concern. That's a list that DNR maintains. I go around and around with DNR about that, but it has no legal consequence. So I would encourage you, and I don't have it addressed in here, but I would encourage if you're involved in these types of activities and you've got a consultant, you suggest that they not include any reference to the DNR species list of species of concern, because they are not legally protected. Again, if you've got a consultant that wants to look at every aspect and avoid any public criticism, that's certainly something that they could and should do, but it's not a legal requirement. We're often asked what the legal requirements are, and that's my opinion. Cultural resources, bricks and bones. Again, if a federal permit is required. We've moved, my latest recollection is that we've relocated probably 3 cemeteries in the last 15 years or so. Wasn't the easiest task, but it was done. Wasn't cheap, but size of the project, these were all large industrial projects, 2 relating to 1 cemetery. The other one was involved in a 3rd cemetery. But that's, again, a requirement if it's a federal permit. A lot of work involved in that, but it's doable, just takes time and money. Most all of these take time and money. But you can solve these things with time and money in most cases. So if they're there, there's a consultation required with what we refer to, and y'all may have heard of as SHPO. That's the State Historic Preservation Office. Stormwater. We are dealing with a lot of stormwater enforcement activity. These are development issues, obviously pre-development authorization, but development issues. And you're obviously familiar with that, particularly if you either act on behalf of the developer during the project or some other role that you might play leading up to getting all the permits prior to closing. This is a significant permit is required before any land disturbing activity commences at the site. It also is only temporary. It only requires that the permit be enforced and complied with until the site is stabilized. At that point, it's important. Submit a notice of termination and get the heck out from under the permit. We see all the time that contractors and consultants and developers neglect to submit the notice of termination, and as long as that permit coverage is in effect, you're subject to the permit requirements. So be mindful of that as well, that the NOT gets you out from under it. DHEC verifies that you've complied and accepts, issues a letter accepting the notice of termination, and you're out from under the project. Unless it is one of the 9 categories, or 11 categories, I think, of industrial activities that require an ongoing stormwater permit. Asbestos. Asbestos is very important. I'm dealing with an enforcement action right now for a client, a consultant that just stripped the interior space of one retail space in a shopping center and was unaware that there was asbestos under the floor tile, which was covered by carpet. The consultant had been provided a letter from an asbestos inspector that said all of the asbestos had been removed. Their contract said the scope did not include asbestos. DHEC wants 10 grand. So it's important to note that DHEC takes a rather broad liberal view that anybody's expected to know that there's asbestos or would have asbestos present. The survey for asbestos in a building, if you're involved in development where there's going to be demolition or renovation for commercial purposes, can't be more than 3 years old. It's important to be mindful of that, and that if it's demolition, it actually requires a permit from DHEC, not just the county, or other local jurisdiction, but from DHEC, even if there's no asbestos present. I think they just want their $50, best I can tell. Surveys are obviously prudent. They eliminate matters of survey in title insurance policies, but they can also aid and assist in identifying other physical features, like a manhole where a sewer line might be running through the property that you weren't previously aware of. So it's important to have a survey because it can identify those types of features, or monitoring wells that you didn't know were on a rural site, for example. They're a little easier to spot if they're in the pavement on a corner gas station, but they're not as easy to spot if they're out in the middle of the woods, but they were being investigated for a site next door. And these are the types of things that we found even in an urban site in Columbia that were not discovered by the consultant. They actually did not see some monitoring wells because they were obstructed, but the surveyor did find them. Just some types of activities that a survey should depict. Manage environmental risk. Contracts. It's important, as I said before, the contract include certain things and not include certain things, depending on whether you're a seller's representative or buyer's representative. Purchase contract. You certainly, as a purchaser, want the right to inspect. You want the seller to indemnify or escrow. One important consideration for USTs, and this is a change in position of DHEC lately. If you're involved in a closing that has previously had USTs, or might still have USTs, petroleum underground storage tanks, and there's been a release reported, if the deductible under the superb statute has not been satisfied, DHEC will look to the buyer post-closing if the seller nowhere to be found. So we've now begun to advise, well, we have been always advising if they've asked, that you escrow the $25,000 deductible or whatever portion of the deductible is yet to be spent. So another consideration. Brownfields program, I'll talk about that, and pollution liability insurance, and Bernie's going to talk about the tax incentives with respect to the brownfield. Excuse me. Seller's interest is not necessarily protected by allowing unrestricted use of unrestricted investigation. I mean, if you due diligence, seller's due diligence, the buyer's due diligence period, during the due diligence period, the buyer can do a phase one, as described in most common terms, and they find something and they don't like it and they walk away. That data has to be reported to DHEC. There are ways to investigate where that might not be required, but generally speaking, soil borings and groundwater monitoring is required to be reported to DHEC. So those things should be negotiated very carefully and not just referring to, quote, standard language in a contract. And you know what the extent of that inspection authority is to be. Buyer's interest, on the other hand, is to have unfettered access to the property for all investigations. So solution is due to Phase I and then probably participate in the Brownfield program to identify the existing condition under the oversight of DHEC. And in most cases, that's more advantageous to the seller because the view on that from the Brownfield program is a lot more lenient in terms of just going in with contaminated property and have it cleaned up by the seller or current property owner. Indemnification, these are good things to consider, not necessarily as a seller, but certainly from the buyer standpoint or escrowing. Phase I, for the Brownfields program, when you want to talk about the Brownfields program, we strongly encourage not proceeding with a Phase II as likely recommended by a consultant that did the Phase I and find something, unless a decision is made to or not to participate in the Brownfield program, because that Phase II money would likely have to be spent all over again to satisfy DHEC's thirst for knowledge as part of the voluntary cleanup contract that the buyer would execute and get liability protection. So there's a stopping point between a Phase I and the evaluation of the results of the Phase I and deciding whether to participate in the Brownfield program before undertaking a Phase II. We believe that that's a prudent evaluation point to consider the Brownfield program. Insurance products, I'm just going to touch on it. Those are available. They're not as easily acquired unless the value of the project can support the cost of them. They're not cheap. So this is just to throw it out there, and the fact that these products still are available in the marketplace, but the size of the transaction will dictate whether to consider it. We've had projects where we've layered all of these types of risk management tools. Good contractual indemnifications, a Phase I for the BFPP defense, voluntary cleanup contract for the state statutory liability protection, and a pollution legal liability policy. But the size of the project warranted that and could support it. Bernie, back up to the Brownfields program, and I say here that the Brownfield program requires the completion of an application. The application, I don't know, 7, 8 pages or so, but it requires submitting the Phase I. That's important, and it has to be executed prior to closing. But the other considerations for the Brownfield program are not just these 3 liability protections, but there are some tax advantages available to a prospective purchaser, a non-responsible party, as the Brownfield program describes. And Bernie's going to touch on those too.
South Carolina has a Brownfields tax credit, and we've had one for a number of years. It's been virtually never used. Literally, only several people have applied for it, and the reason for that is, one, the tax credit is unknown. A lot of people are not aware of it. Second of all, the wrong person, the seller, incurred the rehab expenses, and the credit is based upon rehab expenses incurred by the innocent purchaser, not the seller. Third, some people do wake up to the credit, but they miss the deadline, and there is one of the relatively few tax credits that require an application to be filed. Normally you just take tax credits on your tax return. This one requires an application. Fourth, and this happens with some commonality, the purchaser doesn't think they're going to have a state tax liability, and so they just don't care. We had one not too long ago where the purchaser was a REIT, and REITs don't have state tax liability, so they just didn't want to fool with it. And then lastly, some people wrongfully think the credit is too small to fool with. They look at the $50,000 and they think that's just not worth fooling with. The credit's actually larger than that. The credit is capped at 50% of the cleanup costs by the innocent purchaser. So that's the first cap, 50% of the cleanup cost. It's further capped at taking only $50,000 the first year of the credit, but you have a $100,000 carry forward. So if your expenses are $1 million, you would have a $150,000 tax credit initially. But there's also another $50,000 credit in the final year. It cannot exceed $50,000 and is equal to 10% of the cleanup cost. So credit number 2 is a credit equal to 10% of the cleanup cost, not to exceed $50,000 in the final year of the cleanup. So you're looking at $200,000 worth of credits, and that's real money to anybody, assuming you had $400,000 worth of eligible cleanup cost. There's also an argument, this is not found in the statute, but where you have the cleanup occurring over multiple years, you generate a new credit each year. You sort of reset or start over in year 2. So if you had $500,000 of eligible cleanup expenses in 2015 and $500,000 of eligible expenses in 2016, you got an argument that you have 2 sets of $200,000 credits. That's not in the statute, but that's something certainly you would want to look at. To get the credit, you have to enter into a non-responsible party voluntary cleanup credit. You have to file the tax credit application annually with DHEC, and unfortunately you have to have a CPA report attesting to the accuracy and validity of the cleanup costs. Now your CPA's never done one of those because nobody's ever really gone after this credit, but I would not expect that to be expensive or time consuming. The CPA's not doing a whole lot. So it's a credit that definitely everybody should look into.
You want to talk about the tax deferral?
Well, there's a property tax exemption. You can get a fee in lieu for a smaller amount of capital investment for a Brownfield site, and there's a whole bunch of credits if you're abandoned buildings and abandoned retail revitalization. So there's a number of credits, sort of first cousins of this credit. But the Brownfields tax credit, as I say, has virtually never been used for the foregoing reasons, and it's a lot more valuable than it looks on the surface.
That's pretty much our presentation, and all I can hope for is that we covered the topics that I identified on the front end, and we still have time if anybody has any questions.
We've got one. It's for a residential realtor that occasionally does a commercial transaction. What are some environmental issues or red flags that a realtor should be concerned about?
Well, for a residential transaction, about the only thing, these requirements for all appropriate inquiry only require what's usual and customary, and what's usual and customary now in a commercial transaction is a Phase I and all of these other defenses. In a residential transaction, usual and customary and these regulations do not apply. However, what I do encounter on a routine basis are questions about heating oil tanks. That's probably the recurring call I get on residential transactions, other than, who can do a closing cheaply. But the residential heating oil tanks are not regulated by DHEC. The criteria for regulated petroleum underground storage tanks is limited to commercial tanks. So if the question is, what do you do about a heating oil tank, for example? I pose that question. I'd say get rid of it. Empty it for sure properly, but it does not require any particular closure criteria or to examine for the presence of any impacts. What might be prudent is not necessarily congruent with what is required. From another standpoint, from residential, I'm not getting into the lead-based paint requirements that are applicable to residential properties. That could be a whole nother hour topic. But be mindful, for example, that a single family or a quadplex to which the asbestos regulations apply, if your client is buying 4 houses, single family houses, or even 1 for that matter, if they're going to tear down a house on the corner of an intersection and put up a gas station or a convenience store, the asbestos requirements apply to the demolition of that house, even though on the surface of the regulation they don't apply to a single family residence. They apply to a single family residence if the intended use is a commercial use. So that's the one thing that I can add in terms of the residential transaction as it relates to a residential broker who infrequently does commercial transaction. Everything we talked about today applies to the commercial transaction. Is that it? We don't have any other questions. If we don't have any other questions, I guess we'll sign off. And we appreciate y'all allowing us to serve up this information and hope that it was of some value to you and that you can help your prospective purchasers and or sellers manage their environmental liabilities.
Just one more.
Oh, you did?
Yeah. You mentioned if the seller is nowhere to be found, DHEC will look to buyer in case of contamination. Is seller still responsible if available? For example, with monitoring wells, if disclosed, can buyer be released?
The comment that I made about that was in the context of the Petroleum Underground Storage Tank Program, or the trust fund that's affectionately referred to as SUPERB. And in the SUPERB context, DHEC has now begun, if the seller, who was the UST owner at the time the release occurred and was reported, has not exhausted its $25,000 deductible for that release, and the buyer has purchased the property, they'll make a minimal, DHEC will make a minimal effort to find the seller. If they don't find the seller, we're in a battle with them right now with our client who bought the gas station 7 or 8 years ago, and they didn't do anything about it for 11 years. And now they've knocked on our client's door and said, we can't find the seller, so you're responsible for the other $21,000 on the deductible. And we said no. So we're in that battle right now about that. So that's why I said that in a transaction involving a regulated petroleum underground storage tank, check the deductible. If the deductible hadn't been exhausted, I would encourage escrowing that unused deductible amount. I think I answered that. I hope I answered that question. We're good? Okay.
All right, well, thank you all for joining us.